Peace, y'all. Thank y'all for checking us out. Today we're going to talk about Rule 5.1. It seems that there's some confusion about this particular rule and how it applies to both state and federal. All right, so let's get into it. Rule 5.1. Let's see what it says. Rule 5.1. Constitutional challenge to a statute. Constitutional challenge to a statute. So they say notice by a party that files a pleading, written motion, or other paper drawing into question the constitutionality of a federal, this is one, or constitutionality of a state statute. So there's two things happening here, right? You can address a federal issue if you have a federal case, or you can address a state issue if you have a state case. All right. Now, most people miss that. So file a notice of constitutional question stating the question and identifying the paper that raises it. So here's what they want you to do. A federal statute is questioned and the parties do not include the United States, one of its agencies, or one of its officers or employees in an official capacity. State statute is questioned and the parties do not include the state, one of its agencies, or one of its officers or employees in an official capacity. See, now here's where I think people get confused. They're giving you, right, in 5.1, a reference to the federal statute. This is the federal, right, statute that they're using for a constitutional challenge. But what's the state statute? All right, so a lot of people have been taught to only use a 5.1 when all you have to do is take a look at your respective state. And I'll give you an example. Here is Texas, and Texas is unique. All right, so it says here legal challenges to constitutionality of state statutes. This is what they call it. This is the code. All right. So let's see what they say. See if they got a little bit more meat to their potatoes. All right. In an action in which a party to the litigation files a petition, motion, or other pleading challenging the constitutionality of a statute of this state, the party shall file the form required by subsection A-1. So they even went as far as to create for y'all an actual form. And this is what the form looks like. Let's see if I can. This is what it looks like. So here you're going to see challenge to the constitutionality of a state statute. And they tell you exactly what you need to do. Case number, style, name, address, whatever this is in terms of motion or petition. And then you got to put the information in here, right? So all of this comes back to Rule 5.1. But people are confused as to how to address something on the state level. So let's go further into 5.1. This is 5.1 federal. So serve the notice and paper on the Attorney General if a federal statute is questioned, or on the state attorney. Like, I don't know how people miss this. It's either or, right? And then you can go down. The court needs to take some action. The court must certify to the appropriate Attorney General, state or federal, that a statute has been questioned. And then intervention. And then intervention, final decision on the merits unless the court sets a later date or later time. The Attorney General may intervene within 60 days after the notice is filed or after the court certifies the challenge. So you could read the rest of that, but again, each state has their own statute on this. All you got to do is just constitutional challenge, right? That's all you got to type in for your respective state. And you'd be surprised. Like the state of Texas, they actually have a form, right? What was I looking over there? All right, nothing that y'all need to see. All right, peace. Check y'all out later. Take care.